So toward the end of your book, could you slide over to Rule 7:2-1? That's where we're going to start on the Municipal Court Rules. Now, just a couple of things in terms of themes that you're going to see throughout the rules or common denominators. One of them is, as a matter of policy, the Supreme Court Committee on Municipal Courts likes to be able to encourage the development of rules that take advantage of modern technology so that the courts and the police and the interfacing they have with each other can be done more efficiently. And you're going to see that several of the rules have adopted or been amended so as to take advantage of either present technology or technology which we anticipate is going to be coming down the line in the future. So the first one about this is number 2, where it talks about if the complaining witness is a law enforcement officer, the complaint may be signed by an electronic entry secured by a PIN number on the certification, which shall be the equivalent and have the same force and effect as an original signature. Notice now that this is something that's limited to police. You can see from the earlier amendment to the rule where it talks about certifications on these things, the complaining witness shall attest to the facts contained in the complaint by signing a certification or an oath before a judge so authorized under 2B1221. 2B1221 is the statute that lists out the people who are authorized to take oaths in New Jersey. Notice that they use the word certification or oath. Certification or oath, there's no distinction in New Jersey law in Rule 1:4-4, where they have either oath or affirmation or certification. They legally are indistinguishable from each other. It doesn't make any difference. Going down a little bit to B, this was kind of carved out, and I think this is more placed where it is as a training issue to help accent its importance. The municipal court administrator or deputy court administrator shall accept for filing every complaint made by any person. This rule is grounded in the First Amendment to the United States Constitution, dealing with the right of people to petition their government for redress of grievances. And the idea is that anybody who has a complaint should feel free to go to the municipal court and file the complaint, and that complaint will be accepted for filing. A couple of things I want to point out about this rule, just to put it in a little bit of a deeper context. The New Jersey Supreme Court in State versus Storm, this very famous case that we're all familiar with, talks about the municipal courts being a safety valve for people who are on the verge of violence, and rather than resort to slugging it out on the street or engaging some other type of criminal conduct, people should feel confident that they can go to the court and the court will in fact accept whatever complaint that they have for filing. So the court has a safety valve and the ability to people to go there and resort to the court as opposed to resorting to some type of self-help is very important as a public policy matter. Now, the fact that the municipal court will accept the complaint for filing is fine in and of itself, but that doesn't necessarily mean that process is going to issue either in the form of a summons or a warrant. You still have to go, after it's been accepted, through the screening procedure by a judicial officer to make a determination as to whether or not there's probable cause, and if there is probable cause, what type of process is going to issue, be summons or warrant. So you have a situation where, although the complaint may be accepted, it may wind up being dismissed just on the basis that there's no probable cause to believe that's happened. And I think that that's a distinction also that's really kind of a training issue as well for the court staff, don't you think, Judge?
Correct.
All right. Under D, by the way, you can see that because of the adding of B, they had to renumber the sections of the rule. The arrest warrant shall be made on a complaint, CDR2, or other form prescribed by the AOC, and signed by the judge, or when authorized by the judge, the municipal court administrator or deputy administrator. And I think, although the language is inartful here, the judge will have to authorize both the deputy and the court administrator. Do you agree with that, Judge?
Yeah, I actually enter in order, so there's no question. A pre-arranged order giving blanket authority to my court administrator and deputy to do that.
Okay. After determination of probable cause. Electronic signature by the judge, authorized municipal court administrator or deputy administrator shall be the equivalent to and have the same force and effect as the original signature. So this is the opposite side of the coin, where the electronic signatures of members of the judiciary would have the same force and effect as the electronic signature by the law enforcement officer coming in. So it's kind of like, going out both ways over the internet or fax or whatever it may be. Citizens' complaints. This is a major change to the law. And there's a whole lot going on this, so we have to kind of get into some detail here, all right? Just a little bit of background of what triggered this. You'll have in the municipal court context situations, especially in traffic cases, where there's a lot of civilians involved and very short statute of limitations. You'll have people who will come into court and want to sign complaints, charging, they get in an accident, the police give one side a ticket, and then the people are not happy, and they decide they're going to go down and sign a ticket against the other driver. Very, very common occurrence. But occasionally what would happen is the civilians would come into court and sign it out of the statute of limitations. So court administrators were placed in a position where the people would wander in off the street, they would accept the complaint for filing, they'd submit an affidavit of probable cause, a judicial officer would review the affidavit of probable cause, find the probable cause existed, and then issue process invariably in the form of a summons, okay? That means that some defendant somewhere now is going to get served with this and have to come into court and answer up to a charge which on its face should wind up being dismissed because it was filed outside of the statute of limitations. It's a waste of time for the defendant who's coming in. It can result in certain unfairness because if it's out of the statute and the defendant doesn't know that and it's not represented by an attorney, is it a function of the judge to say, this is out of the statute of limitations and give them legal advice? Or should the prosecutor be doing it? Or how about if nobody picks up on it? I mean, it just causes all kinds of problems. Let's go through the rules and see how this is all going to play out now. All right. So let's see. Arrest warrant or summons on a complaint charging an offense made by a private citizen may be issued by the judge or, if authorized by the judge, a municipal court administrator or deputy court administrator with jurisdiction in the municipality where the offense is allegedly committed within the statutory time limitation. You have not only a determination that there's going to be probable cause, but also that the filing has been made during the statute of limitations period, okay? The warrant may be issued only if it appears to the judicial officer from a complaint, affidavit, certification, or testimony there's probable cause to believe that an offense was committed, the defendant committed it, and an arrest warrant can be issued, meaning that it's within the statute of limitations period. The judicial officer's finding of probable cause shall be noted on the face of the summons or warrant and shall be confirmed by the judicial officer's signature issuing the warrant or summons. If, however, the municipal court administrator or deputy finds that no probable cause exists to issue an arrest warrant or summons, or that the applicable statutory time limitation to issue an arrest warrant or summons has expired, that finding shall be reviewed by the judge. The judge finding no probable cause to believe the offense occurred, or that the statutory time limitation to issue the arrest warrant or summons has expired, shall dismiss the complaint. So you've got two things you've got to keep in the back of your mind here. Number one, is there probable cause? And number two, is the filing taking place within the statute of limitations period? Typically what's going to happen now is that if the judicial officer who's reviewing it initially doesn't find PC or finds that it's out of the statute, she should take it over to the judge. The judge will then review it, and if the judge makes the same determination, the complaint will wind up being dismissed. Now, as a practice tip, we've got a couple things going on here. Number one, it's now very foolish if you're going to have your client file a complaint against somebody, waiting till to the 29th day. If it's a traffic ticket, say, all right, get out of there on the day before it's supposed to expire and have it reviewed. Because what may happen is, if it's a small court, the judge or the judicial administrator, the court administrator or the judge may not review it, review the probable cause determination until after the 30 days is over. And at that point, it's going to be out of the statute. The process can't be issued at that point. The second problem that comes up is with this Bukowski case that Judge McGady was talking about. McGady is the, In re McGady. Bukowski is the case that stands for the proposition that not only must you file your complaint within the statutory time period, but the defendant has to be served with it during the statutory time period. Now, most of the service of the process is going to take place through, under Rule 444 by mail. You'd be very foolish to wait to the 29th day and have your client go down and sign a complaint against somebody and expect that it's going to go through the entire process and then get mailed and received by the defendant within the statutory time period, okay? Because really, when you stop to think about it, you don't have any control over the vicissitudes of the mail, but more importantly, you don't have any control over when it's going to physically leave the building, the municipal court, and go out into the mail. It may be a situation where the court is mixing their mail in with the rest of the municipality's mail, and they may only take it once every 2 days, or they miss the mail delivery for a day, or it's over a weekend. There's just too much going on here for you to take a chance. So I guess the way to handle it to make sure you don't violate the Bukowski and avoid all these problems is to file your complaint much earlier in the process. Give yourself a couple weeks to do it. All right, 3 is new also, and again, this requires a little bit of a background. This started off with a case, and again, I'm too lazy to look it up, but I think it was about 1989. It went to the Supreme Court under the caption of State versus Gonzalez. But in the law division, it was decided by Judge Haynes down in Burlington County, and At the time, municipal court rules, Part 7 rules, were not particularly well drafted and relied upon the Part 3 rules to a certain extent, actually to a significant extent, for procedures in municipal court. And so lots of times you'd see there be cross-references between Part 7 rules and Part 3 rules. One of those cross-references persuaded Judge Haynes to believe that before a police officer could issue a traffic summons, or that's, process could issue on a traffic complaint by a police officer, that an independent probable cause determination had to be made by a judicial officer. Now, you can imagine that this would have put it just would have created total turmoil in the ability of law enforcement officers to issue summons. You think about state police who are out running tickets all the time, all over the place for a wide variety of jurisdictions. For them to go from court to court to court to have individual probable cause determinations made on each one of their tickets is just impractical and really not necessary. The case went to the New Jersey Supreme Court, and in the Gonzalez case, the court made a couple of determinations. The first of all, you should understand that the court's decision in Gonzalez was the linchpin, not the linchpin, but the impetus to have a standalone Part 7 court rule, which we now have. I think it went into effect in '87, Judge?
Sounds about right.
And one of the elements of style that the court expects us to follow, and you'll see coming up in some of the rules here, no cross-references anymore to other court rules, especially to Part 3. Just you kind of stay within Part 7 to avoid all these problems. But the main decision by the Supreme Court was that law enforcement officers are privileged in New Jersey to make their own probable cause determinations as long as the process they utilize is going to be on a summons. And this would apply both for traffic offenses, offenses charged on a special form of summons, a complaint, and DPs and petty DPs. And the reason for this is because most law enforcement officers are acting in a professional capacity. They don't have any personal animus against the people that they're arresting or charging. And if they do misbehave, they have the possibility of being prosecuted for official misconduct, or even more seriously, 2C29-1, obstruction of the administration of law. So the court felt that that was enough of a safeguard that law enforcement officers could issue their own summonses, and that's been the state of our law since that time. Now, the problem that you run into is that you have a lot of people who are public employees who are doing work which is quasi-type law enforcement, but they're not law enforcement officers in the police sense. They haven't gone to police academy. They're not normally eligible to carry firearms and that type of thing. And code enforcement personnel are typical of these individuals.